LS&S Employment Law Overview for Managers, Supervisors, and Directors Part 1. This is a high-level overview for awareness. Should you encounter a situation related to anything mentioned in this video, please contact the Human Resources Department. The intent of this video is for informational purposes only. In no way is this video intended for legal advice or guidance. With your help, we will ensure that we are in compliance with federal, state, and local laws. Under your watch, don't break the laws, and don't allow employees to break the laws either. You are part of the LS&S management team. You should have a basic understanding of the laws. There are 3 types of laws that you should know. When making any management decisions, consider these 3 laws: your federal laws, your state laws, and your local laws. Federal law is a body of laws created by the federal government of a country. In the United States, nothing prevails U.S. federal law. Federal laws are enforced throughout the United States. Each state has its own state laws and regulations, which impacts the employees and at times impacts the employer. These laws provide additional protections and include different regulations. It's just dependent on the state. State and local laws apply to people who live or work in a particular state, commonwealth, territory, county, city, municipality, town, township, or village. In short, laws may vary in the different cities, counties, or districts. If there are multiple laws that you feel pertain to one specific situation, best practice would be to go with the laws that protect the employee the most. Keep in mind there are times when multiple laws may run concurrently. Please contact the Human Resources Department if you find yourself in any of these examples stated in this video. Now we will go over a few laws you should know, along with some of the history pertaining to certain laws. Here are some of the laws that will be reviewed in this video and some of the agencies that oversee these laws. Laws protect the employees and the employer. Title VII of the Civil Rights Act of 1964 protects individuals against employment discrimination on the basis of race and color, as well as national origin, sex, and religion. Title VII applies to employers with 15 or more employees, including state and local governments. Keep in mind that the Civil Rights Act of 1964 and Title VII impacts you as a manager. The law impacts your hiring decisions, termination decisions, compensation decisions, benefits, and all employment practices. The Civil Rights Act of 1991 modified some of the basic procedural and substantive rights provided by federal law in employment discrimination cases. It provided the right to trial by jury on discrimination claims and introduced the possibility of emotional distress damages and limited the amount that a jury could award. Once these laws were put into place, everyone looked around and said, "Now what do we do? These laws are in place, but who's going to regulate them?" The U.S. Equal Employment Opportunity Commission, or the EEOC, is the agency that is in charge with enforcing these laws. Under the watch of the EEOC are the following laws: the Equal Pay Act, Age Discrimination Employment Act, Americans Disability Act, Genetic Information Non-Discrimination Act, Immigration Reform and Control Act, Harassment Training, Pregnancy Discrimination Act. The Equal Pay Act of 1963 is a United States labor law amending the Fair Labor Standards Act aimed at abolishing wage disparity based on sex. It was signed into law on June 10, 1963 by John F. Kennedy as part of his New Frontier program. If you receive a communication or request from the EEOC or other federal agency or state agency, forward them to HR immediately. Do not respond to them yourself. Unlawful age discrimination happens when someone is treated unfavorably because of their age without justification or is harassed or victimized because of their age. This law protects people who are 40 or older from discrimination because of age. This law makes it illegal to discriminate against a qualified person with a disability in the private sector and in the state and local government. The definition of disability is quite broad. Anything that affects a person's daily life, such as alcoholism, blindness, allergies, can be considered a disability. The reasonable accommodation process is required by federal law, and all states are required to comply. Employers must have in place a reasonable accommodation process. This form, the request for reasonable accommodation, along with instructions and the process for reasonable accommodation, can be located at the LS&S intranet website. The law requires that employers reasonably accommodate a known physical or mental limitation of an applicant or an employee. It's important for employees to talk to you about their needs for reasonable accommodation. Employees should bring information from their doctor regarding their restrictions. As a manager, do not make accommodations on your own. We want to leave it up to the experts. Retaliation includes any adverse action taken against an employee for filing a complaint or supporting another employee's complaint under a variety of laws. Reasonable accommodation is any change in a work environment or in the way a job is performed that enables a person with a disability to enjoy equal employment opportunities. GINA, the Genetic Information Non-Discrimination Act of 2008, protects information about an individual's genetic tests along with any family member's genetic tests, as well as information about the manifestation of a disease or disorder. IRCA makes it illegal for certain employers to fire or refuse to hire someone based on a person's national origin or citizenship status. It also makes it illegal to request employment verification only from people from a specific national origin or appear to be from another country. LS&S participates in E-Verify. U.S. law requires companies to employ only individuals who may legally work in the United States, either U.S. citizens or foreign citizens who have the necessary authorization. This is the end of the Basic Law Overview. Please proceed to Part 2. If you have any questions regarding this video or any HR questions, please feel free to contact victor.hernandez@lsslibraries.com or Maria Ariza at lsslibraries.com.